Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. Today, we have a fabulous webinar. What happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous construction attorney, the one and only Mark Cobb.
Wow. Thank you, Ariella, for that wonderful introduction. How you have this much energy on a Wednesday morning is very impressive. But that's why you do what you do so well, the notices and liens, etc. But thank you all for attending today. As Ariella said, I am Mark Cobb. I'm the founder of the Cobb Law Group, which is a firm that focuses exclusively on construction law in the state of Georgia. We have a statewide and regional practice. All of our attorneys speak and publish regularly on the various topics related to construction law, including contracting, liens, and payment bonds. Most recently in 2020, I was on a legislative committee where we changed the lien laws. And so we file literally thousands of liens every year. And we have a very common question: what happens after I record my lien? And so Ariella suggested we make this a surgical topic for today. The second slide is actually just some administrative things. We do take questions, and we hope that you have some very interesting questions on this topic. You're welcome to use the chat box on the right and put your questions in. And then at the end of the program, Ariella will read the questions, and between the two of us, we will help develop some answers for you. We do remind you that if you ask questions, don't include any of your names or company names, because other people may be able to see your questions. But getting back to the topic today, so we're going to have 4 general topics. The first one I'm a little scared of is a brief overview of Georgia's lien laws. As you can imagine, we can do our seminars just on this topic that can last in an hour, 2 hours, and we're not going to do that today. Just to remind you of a few deadlines and a few key things as we go into the main topic, which really is options and deadlines to enforce liens. And that's where we get into the meat of what do we do after we file our liens. After we discuss that, then we're going to talk about what it means to perfect your lien in the state of Georgia, and then finally, how to foreclose your liens in Georgia. So we'll start with a brief overview of Georgia's lien laws. And first, I always like to remind people, what is a lien? And a lien is really a remarkable device. It's basically the ability to get collateral for money you're owed. So if you're financing a car and the car company takes an interest, the car finance company takes an interest in your car, and if payment is not made, as everybody knows, the finance company can come pick up the car. The same thing with a mortgage company on a house or a building. Well, the remarkable thing about liens is that someone who does not have any contractual obligation with the owner, somebody who's working for a general contractor, subcontractor, for example, or a supplier, if they are not paid, the law presumes that the work or the services or materials which they supplied benefits the owner. And so after you've done the work, if you haven't been paid, and if you comply with all the state statutes, then you can obtain a lien. And again, that lien is your collateral that you will get paid. So it helps significantly if you're able to file your liens. And in Georgia, lien rights are broadly construed. Subcontractors, suppliers, even sub-subs qualify for liens, as do foresters, architects, engineers, heavy equipment rental companies. There are many potential lien claimants in the state of Georgia. In order to preserve your lien rights, certain subcontractors and suppliers to subs must comply with the notice provisions in the Georgia statutes. These documents are commonly referred to as a notice to owner or a notice to contractor. Some other states call them notices of furnishing, but it's a document that the potential lien claimant has to send to the owner and the GC within the first 30 days in which they begin supplying materials or providing services. That gives the general contractor and the owner an opportunity to say, hey, who's actually working on the project? Makes sense. The owner knows who the general contractor is because he or she has hired that contractor. The contractor in terms knows who the subcontractors are on the job, but they don't know who the subs are or who are supplying. And by sending this notice to owner, you're giving notice that says, hey, we're preserving our lien rights, and if we're not paid, we will file lien rights, and we have them because we've sent you the notice to owner, shifting the obligation to you, the general contractor or owner, to make sure that payments flow downstream. Another point is Georgia lien waivers. They're very tricky. Only a few states have a statutorily required lien waiver, and Georgia is one of those states. The lien waiver that is published in the statutes is the only enforceable lien waiver in the state. We actually have two. There's one for interim payments and one for final payments. They are tricky because they are conditioned upon payment for 89 days. So in other words, you sign it and you say, I'm signing this, and it's conditioned upon payment for 89 days. However, on that 90th day, and there's language in the lien waiver that expressly says this, on the 90th day that conditional lien waiver converts to an unconditional lien waiver. So it's very important for anybody who's working in Georgia, when they sign lien waivers, to make sure that 89-day does not lapse. Just let you know there is a mechanism for voiding the lien waiver. It's called filing an affidavit of non-payment, and that too can be a webinar on its own. I want to remind you that the deadline to file a lien in Georgia is 90 days from the last day that was worked or the last day that materials were supplied. It is not an invoice date, but someone had to physically be on the job doing work under the contract. It would not include warranty work or the last day that materials were physically received at the job site. Generally in Georgia, because lien rights are broadly construed, the amounts that you can request in your lien is the full amount of the contract. If the contract is terminated and it's not the lien claimant's fault, then the lien can include profit and overhead on the unperformed portion of the contract. Because liens are such an amazing mechanism, again, the idea of getting collateral from a third party after you performed your work is really quite remarkable. In order to enforce that, every single aspect of Georgia's lien laws have to be strictly construed. That's the legal term the courts use that says you cannot miss dotting an I or miss crossing a T. There are even cases that say typos have violated a lien. So that's just a quick overview of what we do in order to get a lien. But the bulk of the question is, what happens after we file the lien? And I do get that a lot from our clients. And it may seem a little frustrating, but because every project is different and every timing is different, there's not a set answer. So really, you have to determine an analysis. It's partially a legal analysis, but probably more importantly, it's actually a business analysis. What do I do with my liens? You want to look at what's going on with that particular project, for example. You may want to find out if there's a closing or refinancing that is going to occur. If so, we do our best to try to find out who the real estate agents are that are involved, who the closing attorney might be, or the potential lender, so that we can get them a copy of the lien. The lien is recorded at the courthouse, and it should be found when a title abstractor goes to the courthouse to look at the title for the property that's being conveyed. But we don't like taking that risk in case the title abstractor were to make a mistake. And as you can imagine, particularly with, say home building, someone's coming in and building 200 homes, that title can actually be, rather confusing because you've taken a large tract of land or perhaps an assemblage of land and divided it into multiple parcels for sale. And the houses are selling, quickly. So we want to know who's buying it and get them notice of the lien, because the lien has to be dealt with before the closing. And so it's an ideal opportunity to do something to try to get paid. I always ask our clients, do you want to be aggressive in pursuing this lien, or do you want to be passive? There is no immediate obligation to do anything with the lien. So sometimes it is best to do nothing. A clear example would be if you know there is a real estate closing, the property is being sold, you might want to wait and see if you get paid voluntarily. Another reason to be passive, perhaps you're a subcontractor and there's a payment issue between the owner and the general contractor. And you want to kind of see what happens with that rather than being aggressive and spending money pursuing your lien rights. An example of that, I even just yesterday got a call from a client who asked if it was worth filing a $7,000 lien. And I happen to know the GC that is involved, and I know, unfortunately, the GC is involved in quite a bit of litigation. And, my advice was, let's go ahead and file the lien, and let's see what happens with this litigation. It might distract the general contractor. Unfortunately, it might cost him so much that he ends up going out of business. But the bottom line is, when it comes time to enforce the lien rights, our client, if he waits a little bit, might be able to do it for a very low cost. He might file suit against the general contractor and basically obtain an immediate judgment, either a default judgment or a consent judgment. Whereas right now, the general contractor might try to fight, and that would cost him more money. Now, aggressive, absolutely, there are clients who want to be aggressive, and that is something that can, we certainly respect and would be glad to do. You tend to look at the value of the debt to be aggressive. I mean, if you're owed $250,000 and you're a smallish business, that could be a substantial part of your annual income, and you need to be aggressive. And we'll get into what that means to be aggressive, but basically, there are several opportunities of trying to bring the parties together to talk, to negotiate, and certainly filing suit or commencing an action. Another thing we look at when we advise clients what they should do with their lien claim in the beginning is look at other claims. That gives you a lot of information. So if our client files a lien against a project and then wants to know what to do, we're going to see what other lien claimants are out there. If our client is the only lien claimant on a large project, it might be an indicator that perhaps our client might have some exposure that they're maybe otherwise unaware of or haven't shared with us. If there are multiple lien claimants, then it's easy to say, well, maybe somebody upstream is having problems, either the general contractor or the owner, and you try to figure that out so you can figure the best strategy moving forward to get paid. So in Georgia, after you file a lien, your lien is good for 1 year from the date of filing. And so that 1 year is an opportunity to assess, to strategize, to try to get payment passively, aggressively, whatever tact works. But if you want the lien to extend beyond that 1 year period, then you're going to have to commence an action. And we'll talk about commencing an action in just a minute, a little more in detail, but that 1 year deadline is very important to remember. And obviously, you're more often than not going to be using an attorney to help you with this. In fact, if you are a registered entity such as a company, a corporation, an LLC, then you have to use a lawyer in the state of Georgia to help you enforce this. But you want to be able to give that attorney ample time to prepare an adequate lawsuit and to get it filed. There is one exception to the 1 year filing deadline, commencing deadline, and that is if the owner or the GC of the project files a notice of contest of lien. That's a document, and it's kind of misnamed. It's not really, it is contesting the lien to a certain extent, but it's not really contesting the lien. It's not contesting the technical aspects of the lien. It's not contesting the legal aspects of the lien. All it does is it reduces that 1 year deadline. Again, that's 1 year from the date the lien was filed. The notice of contest of lien reduces that 1 year period to 60 days from the date of the notice of contest of lien in order to commence an action. So really all it does is it shortens your statute of limitations from 1 year to 60 days. And, depending on when the notice of contest of lien is filed, you're still likely going to get, more time than 60 days because I've never seen a notice of contest filed the same day that a lien was filed. But that 60-day period makes you decide how aggressive you're going to be and how much money you're going to put forward to collect your own money. So in Georgia, we have a two-step enforcement process in order to get the lien to extend beyond that 1 year period. or if a notice of contest is liened beyond that 60-day period. And this is called perfecting the lien. And so perfecting is just a legal term that relates to the additional steps required to be taken in relation to a security interest. And you take these steps in order to make it effective against third parties. So again, think about a lien. If you're a subcontractor or supplier and you've had a contract with a general contractor, you're trying to enforce the lien against the owner. And that's what perfection means. We're going to take certain steps to do it. In Georgia, those steps, it is required that the lien claimant commence an action. That's step one to perfecting a lien. And commencing an action commonly means filing a lawsuit. But it's wise to look into your contract, because if your contract has a mandatory arbitration provision, then fulfilling the steps required by the contract and by the rules governing the arbitration, that is also considered commencing an action. If the general contractor or the owner filed bankruptcy, there's a mechanism for commencing an action under the bankruptcy code. If the general contractor absconds and leaves the state, there's mechanisms for that. So there's several ways to commence an action, but the single most popular way is to file a lawsuit. And the second most common way is to file a mandatory arbitration claim. I like to point out that filing a lawsuit in Georgia, the lien claimant files a lawsuit against the entity with whom it contracted. So an electrical subcontractor most likely has a contract with the general contractor, not the owner. And so this first step to perfect the lien could potentially be filing a lawsuit against the general contractor. The owner comes later. So commencing an action is step one to perfecting a lien. Step two is filing a notice of filing of action to enforce a lien. And that must be done within 30 days from the commencement of the action. It's a long word, it's a long document, or it's just a short document, but a long title. Notice of filing of action to enforce a lien. That's basically a document that's put into the lien record. It's cross-referenced with the original lien, and it says, hey, I'm the lien claimant. I have perfected my lien. And I did it by, and then you describe the lawsuit, and there's certain statutory information you have to give a lawsuit, or you describe the demand for arbitration or the bankruptcy mechanism, etc. And it gives notice to the world that your lien was filed, and within the 1-year deadline or the 6-day deadline, you have commenced an action, and now your lien has extended beyond that 1-year period. So step one to perfecting a lien is commencing an action, and step two is filing that action to enforce lien. Now let's assume that we are trying that after you commence an action, the lien claimant prevails. So you have a couple of opportunities at this point. You can certainly collect from the entity with whom you contracted. So again, if you're the electrical contractor and you have filed a lawsuit or you've arbitrated the claim with the general contractor and you prevail, there's an opportunity to get that entity to pay you. And it happens actually with quite a bit of regularity. So that's not something to forget. It can be either through a garnishment, it can be through voluntary payment. But that's probably step one. But if they don't pay, then you still have your lien out there. And Georgia has a two-step process. First step is going against the entity with whom you contracted. The second step is, if you win, go against the owner. And that's typically a separate action. There are some opportunities there where you can combine the lien foreclosure with the original lawsuit, but those are less common in Georgia. Possible, but you have to know what you're doing. And one of the key components, so many lien claimants think, oh, I've got this lien, now I'm going to go collect my money. Well, if you want to foreclose, the process is very similar to a mortgage foreclosure process. So it's relatively simple. And yes, the property can actually get sold at the courthouse steps. But I'll be honest, it rarely happens in a lien situation. There's two reasons for that. First of all, the owner or perhaps the general contractor will come forward and pay. I mean, nobody wants to lose their house or their commercial building to a lien claimant. And so owners may have balked at having to pay. I've already paid my general contractor. Why do I have to pay a second time? Well, they may have to, and they might do that to prevent a foreclosure. The second reason is you do have to do some legal research before you foreclose to see whether or not there's equity. If you sell this property at the courthouse steps, will there enough money be recovered to pay your claim? And the equity is not just the amount you're owed, but it has to cover superior creditors too. So in a typical residential situation, for example, you may have a $200,000 mortgage that's ahead of any lien claimants. And so in order to justify foreclosing the lien, you have to make sure they have enough equity to pay the mortgage off and to pay any other superior creditors and your lien. So there's some math involved and some research that must be done. I know I've just flown through these topics, but that's really exactly what I give clients, and so I'd be more than happy to take any questions now if anybody has any.
Thank you so much. I'm going to check our question panel here, and we do have one question, and of course we will be sharing this entire presentation with everyone. You should get this in an email within the next 2 business days. And I believe on one of the next slides, if there are any other actual questions, go ahead and ask. I know sometimes you'll watch these webinars and then you go, oh goodness, I forgot there was this question I had. Our contact information is there, so please feel free to send Mark an email, or of course you can always send me an email. Mark, would you be so kind as to go to the next slide? I believe we have our next webinar.
Sure.
Yes. So the next webinar that Mark will be conducting is Don't Sign a Release Unless It Says This One Thing. You can go to our website, sunraynotice.com/education, and sign up for the next webinar. And again, I think our contact information is on that next slide. Again, so if anyone has any questions, we are here for you. Mark, you as always, do an amazing job. Thank you so much. Such like gems of information.
We do pack it in. I love this little brief format. I think it gives a lot of your customers and our clients an opportunity to just surgically learn a few things, but it's a lot of information in a short amount of time. So we'll be happy to answer any questions at your convenience, and I appreciate the opportunity, Ariella.
No, thank you so much, Mark, and I wish everyone a sunny day.